My name is Monica Guisar. Thank you for having me here today. I'm just a lawyer. I'm not a worker or an advocate. So thank you to you, Ruben, and to the car wash workers for standing up and fighting these injustices at work. Without you, we lawyers wouldn't be able to do the work that you do to help support you. So I very much wish you all the best with your campaign. I'm going to talk about the Pacific Steel campaign. There's a summary in your packet, so I won't go through it all. But basically, the Pacific Steel Casting Company is an example of many, many represented companies where we actually have a labor contract. What's different from our campaign from the ones that were highlighted today is that these are locations that already have a union. We already have collective bargaining agreements in place. And for the most part, that means that these are employers who are trying to do the right thing, who are having at least the minimum standards and above that because they have contracts. And this is an example of many that we've had over the past year and a half of immigration enforcement audits by the government. And it highlights, from our perspective, the fact that many union contractors, in our opinion, have been targeted for federal enforcement by immigration authorities. And while we understand employer sanctions is the law and we'd rather it not exist, it does, and we have to deal with it. And it's an example of us trying to find legal strategies to protect workers' rights, demand employers to bargain with unions, even when government entities are in the company investigating their employment practices or hiring practices. In terms of, I think, the organizing strategy for our campaign, this involved a company where the union and the employer were negotiating their collective bargaining agreement. And this started early January of 2011, last year. Sometime in February, they received a notice from Department of Homeland Security Investigations that they would be conducting an audit. We eventually learned about it sometime in March, after the company had already turned over their documents, the I-9 documents, to the government. And this employer, unlike other employers that we represent where the contracts require employers to notify the union about immigration enforcement, this isn't the type of contract where we had that type of language. But as soon as the union found out, the union established alliance with community groups and community partners in Northern California. And I think what was important there is that we were able to do some things that you may have seen in terms of press. I mean, I think in terms of strategizing with sort of the head person on the community advocacy in Northern California, which we were dealing with, which was David Bacon, we were thinking about how can we show the public and how can we educate the public the fact that these immigration enforcement hurts workers. Immigration enforcement hurts communities, and it's a detriment to workers, it's a detriment to communities. People can't earn a livelihood and they can't support their families if they're not allowed to work because of immigration enforcement. And the fact that these are employers who are trying to do the right thing by having a union contract and abiding by workplace standards. So early on, we did partner with community groups while the audit was taking place. We had educational forums. We reached out to nonprofit groups and lawyers to make sure that at these educational forums, my counterpart in Northern California who worked on the case, Conchita Lozano Batista, was able to go to many of the forums where they had community reached out to lawyers who were there who could help workers if they needed help in terms of immigration referrals. So that sort of strategy, along with the idea of we had to have protests and demonstrations to highlight the fact that workers are going to stand up for their rights and we're not going to allow immigration enforcement to hurt us. All of this was also going on along with sort of the legal strategy where we were trying to stop the audit. And the E-Verify settlement agreement that we have in this case was one of many attempts that we made to try to invoke the operating instruction of the Department of Homeland Security to say, hey, wait a minute, there's a labor dispute going on, you need to stop this audit. So we tried many, but the E-Verify was the one that sort of stuck. And in terms of what that meant is that we demanded to bargain with the employer over every step of the way of the audit. So when they first got the notice, we demanded to meet. We demanded that the employer tell the union what the status of the investigation was and that we wanted to negotiate sort of the timing of the responses once the employer received results of the audit. So typically what this means is at the end of an audit, the DHS says, here's a list of all these people that we think are not authorized to work. You need to re-verify their work documents, or if you don't and you keep them employed, we're gonna find that you violated the law. And so we bargained over that time, and we actually did come up with an agreement, as we do with many employers, over the timing of the audit, because we were talking here about 300 workers. So that was a huge workforce for us that could potentially be terminated. And we negotiated an agreement that was gonna take over 6 months to try to do this in waves of how workers would be let go if they weren't able to re-verify. And the government, after we negotiated that agreement with the employer, the government basically said no, even though initially they said they would approve it. The government said, no, sorry, we're doing our own thing, and the employer did not abide with our agreement. So we filed lots of charges, and the E-Verify charge, we learned about it through these negotiations. I mean, at the same time last year, we asked many union employers we demanded to bargain over E-Verify. Pacific Steel wasn't the only one. But we sent a letter along with the audit saying, by the way, if you're thinking about signing up for E-Verify, you need to bargain first with the union. And their response to us was, we're already signed up for E-Verify, we're a federal contractor. Well, it turned out that was a big lie. They weren't. So we filed charges, and essentially what happened was that the board, the National Labor Relations Board in Region 32, asked us for position statements, and the AFL-CIO, thank you very much, submitted a supplemental position statement along with ours. And eventually they were able to issue complaint. They ended up issuing a settlement agreement with the employer. But basically what the agreement says is that when an employer who's signatory to a union contract is gonna sign up for E-Verify, they have to bargain with the union first. And the E-Verify, I think you had a panel about that this morning, but the Memorandum of Understanding states that either party can terminate the agreement when they sign up voluntarily within 30 days written notice. And so we demanded that of Pacific Steel, and in fact, the board required that the employer rescind their E-Verify participation until they bargain with the union. And the other thing they did, of course, is that under E-Verify, you have a certain time to contest if you receive a tentative non-confirmation, so that they required any workers who were fired during that time period who weren't given the time to contest, that those individuals be reinstated. So that's a good thing, because we've been able to use that in other industries, with other employers, with other unions. Just last week, Region 20 issued a complaint in San Francisco against the Hyatt Hotel with Unite Here Local 2. In part because of the Pacific Steel. Our understanding is that the board will be issuing an advice memo on this issue, so that's great in terms of other employers moving forward. I think the downside for us with Pacific Steel was that at some point, despite our efforts to try to stop the audit, we weren't able to. And despite our efforts with, a public campaign, there was the city of Berkeley and Oakland City Councils, they passed resolutions denouncing the government audits and denouncing the Pacific Steel. Unfortunately, we weren't able to stop the government from doing what they were gonna do. And many, many workers lost their jobs. And despite the fact that we tried to maintain with community, educating the public about the audit and the results, and there's only so much we can do, at some point, the government practice roles and people lost their jobs. And so I think in terms of moving forward and lessons learned from our perspective on this campaign is that there was a rift, as oftentimes there is, between labor and community. And I think there was a feeling of the union should have done more. The union didn't do enough. The union didn't protect their jobs. And of course, in a perfect world, we would have loved to have saved everyone's jobs. But unfortunately, that didn't happen. And so I think out of Pacific Steel, there's also the story of the workers themselves who organized together in Northern California to continue to highlight their plight and to stand up for their rights and to show that what happened at Pacific Steel is an injustice, and that there needs to be a change in terms of enforcement and just the immigration policies in this country. In terms of government interaction, like I said, we worked with both DHS. We tried to meet with DHS. We sent them letters. They wanted nothing to do with us. And the NLRB, filed many charges, and the E-Verify charge was really the only one that stuck. So that's pretty much it in terms of the campaign.